Okay, good morning, everyone. Thanks for participating in today's training. I'm Johnny Barton, Chief Counsel to the Office of Open Government. I'm going to give you a brief overview of the presentation, and then we'll get started. Our presentation will begin with a question and a resolution of that question. Then we'll move on to a review of OOG FOIA advisory opinions, case update, and we'll finish up with questions. Please know that any questions placed in the chat should be sent to all panelists. What is one of the top concerns we hear from the public? And perception is reality. One of the things that we hear most from is that where the public feels as though government is not doing a good job communicating with them concerning their FOIA requests. Next slide, please. And we preach and teach very much the importance of keeping dialogue and communication open with the requesters. It establishes a good relationship in the event that we need some additional time to work on matters. It probably would benefit all parties involved to keep the door of communication open, sending them an email every now and then, letting them know that we're working on it. We haven't forgotten about you. Communication is essential to establishing a good working relationship. We know that right now during the pandemic, the actual time is told, but we also know that many public bodies and agencies are processing FOIA requests. Please be sure that if you are tolling, that you do in fact send an acknowledgement letter to the requester, letting them know that you're tolling the request and processing it according to the updated law. Next slide, please. Again, cooperation on both sides is crucial. On the next slide, please, we'll see that the court actually directed in a decision, discussed the need to communicate and the need to have a good working relationship. In 2016, the court stated FOIA requesters and the district entity receiving the request are not or should not be in an inherently adversarial relationship. Litigation is authorized in enforcement as an enforcement mechanism, but it is not meant to be an inevitable path. Next, please. The court went on to say each case has presented its own discrete issues, but the constant is an apparent inability or unwillingness by both parties to communicate effectively to achieve the objectives emanating FOIA. Both parties seem to have forgotten what FOIA is all about. FOP versus District of Columbia. And there's the citation if you'd like to take a look at that decision. Next slide, please. What are final opinions and orders in the adjudication of matters? We know that pursuant to 2-536, certain information must be made publicly available without the need of a FOIA request. We want to just highlight what our final opinions and adjudications and what our final opinions and orders in the adjudications of matters pursuant to DC Official Code 2-536A3. Next slide, please. The U.S. Supreme Court in NLRB versus Sears Roebuck and Company decided that the adjudication of a matter does not require litigation for an agency to issue a final opinion subject to the proactive disclosures of federal FOIA. And the federal FOIA statute and the district FOIA statute here are identical. So are the definitions for adjudication and order. Courts have found an adjudication by an agency to have also occurred where there was a written decision denying inmates application for parole that contains concise general reasons for the denial, and when an agency issues an engineer report on the valuation of timber. So again, there doesn't have to be adjudication or litigation as we know it in order for an agency to issue a final opinion or an order in adjudication of matters. The courts have found that when action taken by a responsible entity in an agency's decision-making process effectively disposes of the matter before the agency, and when such action is accompanied by a written explanation of the decision-maker's reasoning, and when the decision is more than adversarial, it is a final opinion and order in the adjudication of the matter, as long as it's post-decisional and not pre-decisional. Of course, if it was pre-decisional, it may be exempt under the deliberative process privilege. Next slide, please. Are all private contractors subject to DC Official Code 2-532A3? As we all know, contractors who provide services to the District of Columbia, some of these contractors are now subject to FOIA due to the 2001 amendment to the FOIA statute. But it doesn't apply to every single contractor. This particular opinion had a novel issue of whether a public charter school was a contractor of the District of Columbia for providing educational services. And we decided it was not, for two reasons. First of all, the district has not rid itself of all its responsibilities to educate students. In fact, there are still regular private public schools as we know them. But the law in the legislative history makes clear that it only applies to contractors that provide goods or services that were previously provided by the government but have been contracted out to private entities. And that history cites the Community Partnership for the Prevention of Homelessness as a type of contractor that DC Official Code 2-532A3 is intended to cover. So again, not all contractors are covered under the provision that requires that documents received by them are subject to FOIA. An issue has also arisen as to whether an agency can request from a requester identification for a first-party FOIA request. And unlike the federal government, DC does not have a overreaching Privacy Act statute. Under the federal scheme, a person can sign an affidavit or a notarized statement or an unnotarized statement saying that they are the individual and submit that to the federal government under a first-party request. And the first-party request is when the requester is seeking information about themselves. Unfortunately, the district does not have a district-wide first-party privacy request provision. So absent statutory or regulatory authority, an agency's FOIA identity verification requirement does not have the force of law. DC FOIA does not support a requirement that the requester present valid identification to submit a first-party FOIA request or to obtain the record. Generally, under both federal and district FOIA, the identity of a requester is irrelevant, and the DC FOIA law does not require a requester to provide identification to prove his or her identity. Of course, when there is an issue of standing on an appeal, that identity may come into question. The law goes on to say, except for cases in which the objection to the disclosure is based on a claim of privilege, and the person requesting disclosure is the party protected by the privilege, the identity of the requesting party has no bearing on the merits of his or her FOIA request, and the case is cited. Next slide, please. Additionally, in the DC FOIA statute and regulation and a mayor's FOIA appeal decision, DC Official Code 2-532A, any person has a right to inspect and at his or her discretion to copy any public record of a public body except as exempted. The regulations implementing DC FOIA at 1 DCMR 402.3 do not require that the requester identify him or herself. And that provision reads in relevant part, a request shall include a daytime telephone number, email address, or mailing address for the requester. There is a mayor's FOIA appeal that states that an anonymous person is entitled to submit a FOIA request under DC law and that their identity is generally immaterial. The identity also may come into play if the person is seeking a waiver of FOIA fees for that determination to be made, but generally this is the state of the law. Next slide, please. Reasonable description to conduct an email search. The DC Court of Appeals in FOP versus District of Columbia held that a request for emails from a discrete time period that are sent to or by particular individuals or they're about a particular entity constitutes a reasonable description of the public records in compliance with FOIA. The court also held that a request which meets these criteria does not require further clarification by the requester to the agency. So in essence, if the request contains this information, the courts have ruled that that is a reasonable description for the government to conduct an email search and that no further clarification is needed by the requester. Next slide, please. FOIA response sent in an encrypted email. An agency may not restrict the method a requester uses to submit a FOIA request to the FOIA portal. In this particular case, the agency, and it was pretty, it wasn't intentional, made a strong suggestion that the requester submit his or her request through the FOIA portal and did not advise that they had other means of doing so. As we all know, you can send it by fax, email, regular mail, or a FOIA request can be made in person, and the agency can request that it's reduced to writing, but the agency may not restrict the method by which a requester wants to submit his or her FOIA portal. And of course, we can use a FOIA portal as a means of sending a request. FOIA does not require the delivery of responsive records to the requester in an encrypted email. The statute and the courts hold that it's a violation of FOIA to do so. First, there's no statutory authority under District FOIA or the FOIA regulations for an agency to use an encrypted email to provide records to a requester. And in this particular case, the encrypted email had instructions that it required a password, and it also stated that it would expire, vanish, or disappear within a certain period of time. When this is done, the agency action is pretty much above and beyond the law. Since the record is no longer available to be accessed by the requester after the stated period, the agency is in effect limiting the availability of records to the public in violation of DC Official Code 2-534C. And of course, once an individual is the recipient of a FOIA request, they are free to do with it what they want, and an agency does not comply with FOIA when it produces records and places restrictions on the further dissemination of those records or how they may be used. And there's the case site for that. So again, once records are released to the public in response to a FOIA request, the information belongs to citizens to do with as they choose. When the record expires or vanishes within a time frame, the resulting restriction prevents the requester from accessing or further disseminating of these records. Next slide, please. The public domain doctrine. This comes into play when a otherwise exempt record winds up in the public domain. The court, in this particular case, did not address how or why the record appeared in the public domain, but it basically makes, I think we're off a little bit on the slide. I'm maybe a little ahead on the slides here. Let's see. Can you go to the next slide, please? Okay. Public domain doctrine. And again, sometimes a record that is otherwise exempt winds up in the public domain. And the case that's going to be cited, the court did not deal with how the record or why the record wound up in the public domain. But once it's in the public domain, a public body cannot rely on one of the exemptions of FOIA to prevent the further dissemination of that record. The court will order the release of the record because a permanent and complete copy of the record has been released in the public domain. The party asserting a claim of prior release identifies the specific information in the public domain that appears to duplicate that record which is currently being withheld, and the government does not act or doesn't demonstrate that the specific records have been since removed from the public domain. Next slide, please. This is the case in which cites the current view of this jurisdiction. And one of my questions was, why, if it's in the public domain, would someone then want to litigate the matter? And the court answers that question. Next slide, please. It says Niagara's position is a little odd. If the information is publicly available, one wonders why it is burning up counsel fees to obtain it under FOIA. Next slide, please. But the logic of FOIA compels the results. If identical information is truly public, then enforcement of an exemption cannot fulfill its purpose. So again, that's the public domain doctrine. If a record is otherwise exempt and it gets out into the public domain, please, and you become aware of it, please immediately identify your general counsel so that they can take the requisite action to prevent it from further dissemination. Next slide, please. This is an update to the trade secret and commercial or financial information exemption. Trade secrets and commercial or financial information obtained from outside the government, to the extent that disclosure will result in substantial harm to the competitive position of the person from whom the information was obtained. Next slide, please. In Food Marketing Association versus Argus Media, this is a 2019 Supreme Court decision, the court changed the standard of what is comprised as commercial or financial information. And the court there ruled where commercial or financial information is both customarily and actually treated as private by its owner and provided to the government under an assurance of privacy, the information is confidential within the meaning of FOIA, and under federal FOIA is exemption 4. The substantial competitive harm test is no longer the standard to be applied. It's my understanding that that is the standard that the district is currently using and is using following the federal FOIA mandate. The most recent decision, and this is a U.S. District Court for the District of Columbia case, Benson versus United States, I believe it's in August of 2020, further discusses the Supreme Court's ruling. Next slide, please. Personal privacy exemption. And again, these cases are here for your use if you need some update authority for exempting a matter. The personal privacy exemption, this was a case involving an adoption where evidently the adoptive parent was deceased, and the court discussed the privacy interests, in particular that involving a deceased person. Under FOIA, the privacy interest in non-disclosing of identifying information may be diminished where the individual is deceased, but it does not disappear. Instead, courts undertaking a balancing test must consider the effect of the death on the person in question, along with all the other circumstances surrounding the disclosure request. In particular, individuals who are deceased by definition cannot suffer the personal injuries such as embarrassment that may come with disclosure, where certain reputational interests and family-related privacy expectations survive death. For example, an individual may be concerned about disclosure following death for reasons of reputation, civil liability, or possible harm to friends and family. And again, the citation to that case is listed above. Next slide, please. And this is the most recent case that I found in the District of Columbia Court of Appeals dealing with just an explanation of the deliberative process privilege. A document is pre-decisional if it was prepared in order to assist an agency decision-maker in arriving at his decision rather than to support a decision already made. And material is deliberative if it reflects the give and take of the consultative process. The government bears the burden of demonstrating that the documents qualify for an exemption from disclosure. Next slide, please. Adequacy of search. This is a rather long list of things that demonstrate that a public body has conducted an adequate search. I'm sure based on the court case, if you do all or most of these things, your search will be deemed adequate. An agency fulfills its obligation under FOIA if it can demonstrate beyond material doubt that its search was reasonably calculated to uncover all relevant documents. The issue to be resolved is not whether there might exist another document, might exist any other documents possibly responsive to the request, but rather whether the search for those documents was adequate. The adequacy of an agency's search for documents requested under FOIA is judged by a standard of reasonableness and depends, not surprisingly, upon the facts of each case. It depends, not surprisingly, upon the facts of each case. To meet its burden, the agency may submit affidavits or declarations that explain the scope and method of the search in reasonable detail. The affidavits or declarations should set forth the search terms and the types of search performed, and aver that all files likely to contain responsive materials, if such records exist, were searched. Absent contrary evidence, such affidavits or declarations are sufficient to show that an agency complied with FOIA. If, however, the record leaves substantial doubt as to the sufficiency of the search summary, the judgment for the agency is not proper. And again, the case is cited below. In this particular case, cited various other authorities. That's pretty much going to conclude this portion of the presentation. Listed are our staff, our director, Nikhil M. Allen, myself, our newest attorney advisor, Sharif Deebury, and our IT specialist, who's also a recent person to join our staff, Kevon Bridges. Please feel free to use to contact any of us by any of the means that are listed above, and we're always available to help you and assist you as we can with your questions. That is the end of the presentation, and we'll now entertain any questions that you may have.
Johnny, there are a few questions in the chat box. Do you see the chat box?
Okay, let me see if I can get them.
I can just read it out to you.
Okay.
So the first one is, what about for criminal and medical information relating to a requester's identity?
What about criminal and medical?
And your video just went away.
Okay, let me see if I can get it back. Bear with me for just a second. Okay, I see one question. Can we please get a copy of the slides by email? Yes. You see me, Ashley?
Yes, I see you.
Okay, and the question related to medical and criminal files?
Yes, it related to whether a requester has to identify themselves.
Well, again, there's no provision for identity. And I know this puts agencies in a kind of a pickle. In the particular issue at hand, a person made a 911 call, and they identified themselves as the person making the call, and they had all the particulars, but the agency was in a position where, you know, they couldn't just release it because of privacy concerns. They requested that the person identify themselves, and the person did, and that was the issue. Under FOIA, unless there's a statute or a regulation, for instance, I think Vital Records has a provision where you can sign a statement, and it's in their statute that you can do so by presenting identification, or a family member or someone who has a personal representative can do so. If the records are made by the district and the agency doesn't have a statutory or regulatory authority to request identification, then they can't. But I do know some agencies do have a process in effect that they allow it.
Okay. The next question is, please discuss in a little more detail the public domain theory and what a GC should do to keep that record from further dissemination.
Okay. What the public domain doctrine states is that, you know, a record gets out. And in this particular case, it was by pure incident that some personally identifiable information got out. The agency called, and once they were aware of it, requested the information back from the entity that had it. The entity that had it felt as though, and they actually were the constituents, so to speak, that this nonprofit represented, and they didn't return the action. If legal action is necessary, injunctive relief would be a process. Sending out a letter requesting the information back, doing something to pull in the record that you're trying to get the information back, but using all legal means necessary to prevent further dissemination.
Okay, the next question is, how does FOIA impact fusion centers?
Fusion centers? I'm not sure what a fusion center is. If the requester wants to contact me directly afterward, I'm happy to discuss it with them, but I'm not sure where the Fusion Center is. If Nikel and Cherie are on and they have some input on that, please
Okay.
do so.
We have a Fusion Centers collect and analyze data related to potential security threats.
Okay, are they District of Columbia agencies?
The answer is yes. Yes.
Okay, it may fall under one of the exemptions, something like under the exemption similar to Homeland Security, but definitely a privacy interest or a security interest. So I'd like to, I'm happy to talk with the requester a little bit more offline so we can clarify and make sure that we're both on the same page. But my gut feeling tells me that it should be something that's protected and exempt.
We have a few more. Should agencies post their manuals and policies on the website?
Under 2-536, the proactive disclosure requires that information be made publicly available without the need of a FOIA request. So yes.
Is there a statute of limitation or provision for releasing the encrypted method under Code Section 2-5349C?
Okay,
Is there a statute of limitation or provision for releasing encrypted methods? That's what it says.
Okay, well, public bodies should not be sending emails by an encrypted method. So I guess I'm not sure what if I understand the question correctly. But again, if that requester wants to contact me afterward, I'm happy to discuss it with them and see if we can clarify and make sure we're on the same page.
Okay. Next is the name of an employee working with security information subject to disclosure?
The name of an employee working with security information?
Correct. If that's subject to disclosure.
Let me analyze it two ways. The first way is that all District of Columbia employees, our names, salaries, and positions are already made publicly available pursuant to 2-536. I'm not sure about the nature of this person's, security. I mean, but from that aspect, the information is publicly available. If there's something top secret, so to speak, or undercover that may prevent release in certain documents, video footage where an undercover police officer face is shown or other identifying information, I think in that instance it will probably be exempt and protected.
Okay, that's a lead into the next question. Are there any divisions exempted from responding to FOIA requests?
Are there any provisions?
Any divisions, a division within an agency?
It's not an agency or division that's going to be exempt. It's going to be the information or the record that agency or division is going to be, that the FOIA request, the requester is trying to obtain. Homeland Security is probably most, I guess, I hate to use this phrase, but top secret agencies in DC because of the nature of what they do, but they're not exempt from FOIA. However, if a request is made for certain records, those records can be exempt from FOIA under one of the statutory provisions. So I'm not sure. I don't think there's ever an agency or division within an agency that's exempt. It's not the agency or the division. It's the information or the record or documents that's going to be exempt from FOIA, from release, if they meet a requirement, one of the statutory requirements.
Okay, this is the last one I see. Does a FOIA request to have the presumption of anonymity from public disclosure of their request?
The regulations require that, and I can't cite it right offhand, but the regulations require that agencies keep a record of all FOIA requests and the requests that are made and that they may be made publicly available. Again, a FOIA requester does not have to provide their name in submitting a request. But I'm happy to find the exact regulation and provide that to the requester. And if you want to put the screen back up it's still there with the information on how to contact us, please give me a call or shoot me an email afterward, and I'm happy to discuss it further with you to make sure we're on the same page and that I fully understand your question, and we'll address it accordingly.
That's it. No more questions.
Well, I want to thank you all for participating. Thank you for your questions. And I want to particularly thank Ms. Ashley Cook for putting this Ethics Day program together and for assisting with the slides. So thank you very much. Those who had some questions that require further clarification or confirmation is listed. Please feel free to give me a call or to contact me by email, and we're happy to follow up with you. But thank you so much, and we appreciate your participation with this training. I think we have another training at 1 o'clock today. Cherie DeBerry will be discussing the
Open Meetings Act. 12.
At 12, I'm sorry. We'll be discussing the Open Meetings Act, and then later on, as that 2 or 3, Ashley, for Nikhil.
So Open Meetings Act basic training is at 12, and social media and FOIA is at 2 p.m. 2 to 3.
Social media is at 2 p.m. So please feel free to attend either or both of those sessions. There'll be some follow-up on some of the FOIA issues from a social media standpoint. So thank you so much, and we look forward to hearing from those who had some additional questions or whose questions need some clarity.